death or divorce? Will the petition die with the petitioner? Will divorce end the petition? In this video, I'll talk about the reality of sad event with immigration. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Let's get right into it. Death of the petitioner or principal beneficiary. What will happen to the petition? And of course, we're talking about the petitions that were made or filed on October 28, 2009, because we know that prior to October 28, 2009, once the petitioner dies, finito, the petition ends there, or in other words, the petition dies with the petitioners. Okay, and now Congress went ahead and changed, in other words, changed those rules or amended those rules, and we're going to talk about the qualifying people. Okay, so what is the qualification? The qualification is that the applicant must reside in the United States at the time of the death of the petitioner. Okay, and then the other qualification is that the applicant must continuously live or reside in the U.S. On the date of the decision on the pending application. Okay, and then what else? So basically, those are the two requirements. And who can benefit from the petition once the petitioner passes away? We have pretty much beneficiary of pending or approved immediate relative immigrant visa petition. Then we have any derivative beneficiary of a pending or approved employment-based petition. Then we have the beneficiary of a pending or approved refugee asylee relative petition. Then we have a person admitted as a T or U immigrant, and then we have derivative of asylee. Those are the group of people who can, in fact, basically benefit from the petition even after death of the petitioner. And then when it comes to adjustment of status, then we have to talk about those qualifications. Okay, in order to adjust status at that point, first of all, applicant must meet all other adjustment requirements, meaning that the person must be found admissible. Then we have the applicant meet the residency requirement that we have just talked about, must reside in the U.S. at the time of the petition or at the end, basically at the time of the petition was approved, continuous residency in the U.S. But in case of temporary, okay, travel outside of the U.S., you can actually, you don't need to prove that residence was in the U.S. because it's just a temporary type of travel, okay? But once we have an order of deportation, then residency ends there. Then once the petitioner dies, then the petition dies with the petitioner. Okay, so and then the underlying petition was approved before the death of the qualifying relative. That's when you're trying to get the green card, right? And then the underlying petition is approved under INA 204I. And then the pre-death approval or the underlying petition is reinstated, or the non-citizen was admitted as a T, non-immigrant, or as a derivative asylee. So when it comes to adjustment of status, again, we have to meet the same requirement. Must be found admissible. Then we have to talk about the residency requirement, continuous residency in the U.S. at the time of the death. And let's say that the application wasn't approved, some people still are going to be able to adjust status, like, for instance, people in the T category, and then people who were admitted as derivative of asylee, and then people VAWA petitioners, really. Basically, VAWA says that within 2 years of the death of the petitioner, you still qualify. And then once the VAWA petition get approved, then you can still adjust status. So that's about it. So you have to fit into those category of people in order to benefit from the death, really, of the petitioner, which is a sad event, but the reality of life. Sorry, I have to go now to my second point. The second point, we're going to talk about divorce. Okay, once divorce happens, what is going to happen to the petition that is currently pending with USCIS? If the form I-130 hasn't been approved yet, then unfortunately it ends there, because the basis was that the petitioner spouse is the one petitioning. But now the divorce happened prior to the approval of the form I-130, then the petition ends there, just like a divorce. Then what's going to happen again when we talk about the I-751? So let's say that you got approved, you got the conditional green card, and now you want to require the conditional green card to be pretty much like cancel it. In other words, filing the form I-751, removal of conditions. That's the word I was looking for. Removal of conditions of conditional green card, and then the divorce happened in the middle of it. What are you going to do? Pretty much what you are going to do is very simple. You have to ask for a waiver of the joint filing requirement. You cannot file jointly because you have gotten a divorce. Now you have to file separately. But again, there's a caveat to it. The caveat is still must be able to prove that marriage was entered into a good faith, but unfortunately marriage ended with divorce, which can be challenging. That's a very challenging argument to make once the divorce has happened. And if the divorce takes place before I-130 is approved again, everyone that was under that status loses their status, including children, except that if there is a case of extreme cruelty, the petitioner can keep fighting for it and get adjustment of status through filing I-360. And then children at that point, non-citizen children in that marriage, must be able to prove extreme hardship and they cannot go back home. So children might have some type of options in the middle of all that. So basically what you have to do, if you feel stuck in the process, the immigration process, because it can be challenging, really. It can be challenging. We do offer personalized solutions, but we require that you pay as a consultation fee so that we can assess your case and provide you with proper legal advice, okay? Phone number is 202-751-2180. Email on display, and please just keep in mind that consultation fees apply. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. And this was U.S. Immigration. Until next time, bye-bye.